Royce, what's going on? Good morning, Mr. Burke. Good morning, Miss Story.
Good morning.
Yes,
Hi, Mr. Burke. Do you need a breakout room with Miss Story, or are you ready to go?
a breakout room would be great. Thank you.
Yep, you're welcome.
Oh. Let's see, Mr. Burke.
Good morning, Royce.
Good morning. How are you?
I'm good. How are you?
Excellent. Thank you.
Yeah. Miss Perry.
Good morning.
Hi, good morning. What case are you here for this morning?
Would you like the ID number?
No, just, is it a civil case that you're here for?
I believe so.
Is it under your name?
It is.
Huh. I don't see anything with your name on it. Do you have a case number?
I do.
Okay, could I have that, please?
Sure. It's 224-320. And then the letters G for girl and C for cat.
Okay, hold on one second.
Sure.
Madam Clerk, this is Hal Burke. Can you hear me?
Hi, yes, I can.
I was in the room and it did say that Miss Story was there and unmuted, and I was trying to talk to her and she did not respond. Maybe she walked away from her computer.
Oh, yeah, I don't know. I show her still in there. I can bring her out. I can bring her back out and we can try it again.
So, thank you. And if you could send me back in there, that'd
Sure.
be great. Thank
Okay.
you.
You're welcome. Miss Perry, your case was a consent, and you signed it, so there's nothing going on today.
Amen. Okay. I wasn't sure. And the other company couldn't advise me on it. I wasn't sure if I needed to appear. And I thought, you know what? I'm going to appear just in case. I don't want to
Yeah.
not appear. So
I don't blame
amen.
you.
So I'm all set.
Okay, yep, you are. Have a good
Thank you
day.
so much. You too. Thank you. Bye-bye.
Bye.
Good morning, Mr. Nunley.
Good morning, Judge. How are you?
I am wonderful. How are you, sir?
Great. Thank you.
This is 193825FT, State of Michigan versus Gary Allen Hayner. May I have your appearances, please?
Yes, Royce Nunley appearing on behalf of the defendant. We would waive a formal reading and stand mute to the charges.
Thank you. Mr. Hayner, state your name for the record, please.
Gary Allen Hayner.
Thank you. Mr. Nunley, Mr. Hayner was actually arraigned back on June 6, 2020. The bench warrant was issued after he failed to appear. The recommendation most recently from law enforcement, I'm sorry, Mr. Hayner, you previously had a court-appointed attorney assigned to you. The order for a court-appointed attorney remains in the file. You will have an attorney going forward with you in this felony matter. Sir, you have a right to be considered for pretrial release. The bond recommendation forwarded by Huron Township indicates that there is no known reason to oppose a personal bond for you. And it further indicates that there are outstanding warrants for you for child support and a misdemeanor out of Monroe County, Michigan State Police. This court would note for the record that you had a preliminary examination scheduled in this matter back on January 22nd, 2020. You failed to appear, and the bench warrant has been outstanding for you in this case since January 18th, 2020. January 23rd, 2020. Mr. Nunley, what's your position on bond in this matter, please?
We'd ask that the court impose a personal bond. He turned himself in on this matter. He wasn't picked up or anything like that. He said that he's in the process of buying a house. He wants to get himself a car and he wants to get his life moving forward. He said, he had some problems in the past, but he wants to get in there and get it taken care of so he can move forward. I think in his words, as a normal human, and get things on track. So I think that this is just his first stop. His next stop, is obviously going to be for those other outstanding warrants, the child support warrant out of Wayne County, and then whatever the misdemeanor matter is out of Monroe. But I don't believe he's a risk to society, and I do believe that he's going to come back to participate as he's turned himself in. He's working full time. He's got a good job. He's paying child support for his two children, something like $211 a week for the support of those kids. So I wouldn't like to, see him get in trouble with his job and then, fall behind on those other obligations.
Thank you. Mr. Hayner, although the court has some concern based on your failure to appear in this matter for 3 years now, the court has been persuaded by Mr. Nunley's advocacy and will set your bond at $5,000 personally. You do not need to post any money, but what you must do is appear here next Wednesday, March 1st, 2023 at 9 a.m. in courtroom number 2 with Judge Oakley for your probable cause conference. Again, this case number is 193825FT. Next appearance date, March 1st at 9 a.m. in courtroom number 2. That's live here in person with Chief Judge Brian Oakley. Anything else, Mr. Nunley?
Nothing further, Judge.
Anything else, Huron?
No, Your Honor. Thank you very much.
Thank you. Good luck to you, Mr. Hayner. Have a good day.
Thank you very much.
See you guys.
See you, Royce.
Marianne, I started looking at April the 6th, April the 11th, or April the 18th for possible civil trial dates. I don't know that I necessarily want to put them on our next civil date, which is April the 4th. Oh, you know what? I skipped right over March 7th. I don't know who's going to sit on March 7th, but maybe. Good morning, Mr. Burke.
Good morning, Your Honor. This Story and I were able to reach a resolution. I don't know if she's made it back into your courtroom yet, so
She's not made it back. Give us just a moment, see if we can get her out here.
thank you.
Thank you. Good morning. This is 224955 GC Beaumont Health versus Sean Story. May I have your appearances, please?
Thank you, Your Honor. Hal Burke, P69068, attorney for Beaumont Health on this case.
Thank you, ma'am. State your name for me, please.
Sean Story.
Thank you. Mr. Burke, what is the resolution that the parties have reached?
Your Honor, Ms. Story today will consent to a judgment for the amount prayed for, this includes court costs, and that balance is $1,784.08. However, she requested, and I agreed to $50 a month. That's beginning March 20th. I'm going to prepare a consent judgment for her to review and sign. I'll send it to her by email. She said she could receive it that way and then send it back to me after she's reviewed it. And then I would get it to the court. With your permission, maybe we would be able to do that within 20 days, Your Honor.
Thank you. Ms. Story, you were able to hear Mr. Burke just now?
Yes,
Ma'am, and it's your agreement to enter into a consent judgment with a total balance due and owing of $1,784.08.
yes,
And you'll be making payments on this at $50 per month beginning March 20th, 2023.
yes.
Mr. Burke, what I will actually do is adjourn the pretrial until April the 4th at 9 a.m. back here on Zoom in number 1. Ms. Story, Mr. Burke's office is going to send you a consent judgment. If you sign it and send it back to him, his office will sign it. He'll file it with the court and you will not have to appear in April. I put the April 4th date out there to encourage the parties to get the paperwork signed instead of coming back again, if that makes sense to you.
Yes.
Okay. Anything else, Mr. Burke?
Nothing, Your Honor. Thank you.
Anything else, Ms. Story?
No, ma'am.
Thank you so much. You both have a wonderful day.
Have a great day.
Thank you.
Thank you.
Good morning, ma'am. How are you?
Good morning. Good. How are you today?
I'm well, thank you.
Good.
What case are you here for this morning?
Credit acceptance versus Dennis Brown.
Got it. Okay, thank you.
Thank you.
Mr. Brown appears, do you need a breakout room with him?
Yeah, that'd be great.
Okay. Good morning, ma'am. How are you?
Good morning, how are you?
I'm well, thank you. What is your name, please?
Shawnisa Hemingway McGlon.
Okay, thank you.
You're welcome.
Hello,
Yes.
I'm here.
Good morning. What is your name, please?
Mary Jones.
Thank you. Good morning, Mr. Kine.
Hi, good morning.
Good morning.
Hi, what case are you here for this morning?
I'm really sorry. I have one in front of Judge Martin, one in front of Judge Oakley, and I thought they were both in front of the same judge. It's Crown Asset versus Rachel Perry. Ms. Perry actually signed a consent judgment and faxed it to our office yesterday.
Okay. Yeah, I don't have that on our docket today.
Oh, it's not even docket?
Correct.
Okay. Can I go ahead and just mail it in? Is that okay then?
Sure.
It's strange. It was listed as today
Crown Asset?
versus Rachel Perry at 9 a.m.
Hold on one second.
I'm sorry. Thank you so much.
You're welcome. Sir, it was a consent, yep, and Judge Martin has signed it.
Okay. Thank you so much. I'm sorry for the confusion. I really
No
appreciate it.
problem. All right, have a good day.
You too. Thanks.
Thanks.
Bye-bye.
Bye. Hi, Mr. Morton.
Morning.
How's it going?
Just another beautiful, soon-to-be icy day in Michigan.
I know, that's what I heard. I'm so over this. What case are you?
I have two matters today, according to my records. One is, do you want the case number or the plaintiff first?
The plaintiff.
Holiday Woods versus Mark Adams.
Got it, okay.
And then I also have Rawsonville versus Sumatra.
Got it, okay. All right. If they pop in, I'm just gonna make you a co-host in case you need to speak with them.
No problem.
Okay.
I'll keep an eye out for him, and then I know Judge Martin wants everything on the record. Was it so?
Right.
Yeah.
Yep,
Understood.
okay. Thank you.
Absolutely.
What it is now. You just don't pay.
Alan Thompson, can you hear me?
Yes, I can.
Hi, good morning. What case are you here for?
Ma'am, it says pre-sentencing interview, I guess INT.
No, no, you're in the wrong place. Hold on, let me find out where you're supposed to be.
You're in the wrong virtual.
But it said Lisa. That's who's on here. Lisa M. Martin. Judge Lisa M. Martin. It says pre-sentencing, and then it says must appear Zoom, JM, and it says Lisa M. Martin. Don't know.
Probably means they signed it.
It says they would appear you get a warrant. Always finding something, right? Miss, it says courtroom 4.
Mr. Thompson, I'm gonna give you a Zoom ID that you need to hang up from Judge Martin's, and this is the number that you need to dial into. Are you
Hold
ready?
on.
Okay.
No, I don't have a pen. Hold on. 1 second, miss. Is it ID 58?
No, I'm gonna give it to you. No,
Okay, hold on.
I'll take it. So here.
All right, what's the number?
266 746-8861.
One. Okay,
Okay,
thank you.
you're welcome.
All right, bye-bye.
Hey, good morning. Mr. Garcia.
Good morning, how are you?
I'm good. This is Judge Martin's docket for today. So, did you, does he want
They're taking
MIDC?
care of the paperwork right now.
Okay, thanks.
That's what we're gonna ask.
What? I can't hear you. What?
1 second, I'm sorry.
Okay.
Is he gonna, no, you're good. Is he gonna want, you're gonna want some type of attorney on this, sir? Or do you just want to be arraigned? Okay, you're not interested in having counsel? Okay. Marianne, he says he's not. Are you still with me?
Yeah, I'm here. Yep, he's waving.
Yeah, he's waving.
Okay, thanks. Good morning, Mr. Chisholm. Are you all set with Ms. Jones?
We are. We have come to an arrangement.
Okay, I'll let the judge know. Thank you.
Thank you.
This is 214453 GC Reliable Auto Finance versus Mary Jones. May I have your appearances, please?
I had to unmute myself. Good morning, Your Honor. Jeremy Chisholm, P74670. I'm the attorney of record for the plaintiff.
I'm Mary
Ma'am,
Jones.
state your-
Mary
Thank you, Ms.
Jones.
Jones. Thank you. Today's the day and time set for hearing on the defendant's motion for installment payments. Mr. Chisholm, is there a resolution of this matter?
There is, Your Honor. Ms. Jones and I were able to work out an arrangement whereby she would be paying, we'd enter an installment payment order in the amount of $200 per month, beginning April 28th of this year, and that the garnishment that is currently active be suspended.
Ms. Chisholm, I'm sorry, Ms. Jones, were you able to hear Mr. Chisholm just now?
Yep, I heard him.
And ma'am, is it your agreement to enter into a payment plan of $200 per month
Yes,
with your first payment being due on April 28th, 2023,
yes,
and the current garnishment to be suspended?
yes, ma'am.
Ma'am, you understand that if you fail to make that payment, those payments as agreed on time, the plaintiff may file a motion to set aside the payment plan and resume garnishment?
Yes, ma'am.
Do you have any questions, Ms. Jones?
No,
Anything else in this matter, Mr. Chisholm? No, Your Honor, does the court have an order there, a standard scale order that it can mail out, or do you need me to submit one?
There is not one in the file, but I will send it back downstairs for the civil department to prepare.
Okay, thank you, Your Honor.
Anything else, Ms. Jones?
nope, that was it, ma'am.
Thank you. Have a good day,
Thank
ma'am.
you.
Good luck to you.
You too.
Thank you, Your Honor.
Thank
Good luck,
you.
Ms. Jones.
This is 221002 GC. This is credit acceptance versus Dennis Brown.
Good morning, Your Honor. Attorney Ashley Nonis on behalf of plaintiff.
Ma'am, today was a day and time set for, well, plaintiff's office filed a motion to reinstate case and set pretrial hearing.
We did.
The court was actually going to treat today as a pretrial, as the case had not been dismissed. It had been on the court's lack of progress docket. Mr. Beach appeared with the defendant back on June the 7th, 2022. It indicated on the record that a consent judgment was forthcoming and the court has not received one. Has your office received a signed consent in the interim?
No, and that was the problem. So that same day, Mr. Beach had emailed the defendant the consent judgment. We did not hear back from him nor get the signed copy. So we've been trying to call him repeatedly without any luck. When we had the non-progress hearing, I appeared for that and I was under the assumption that the defendant was also appearing. So I was going to use that as an opportunity to see what was going on. I learned otherwise, that the defendant doesn't appear. So that's why I filed the motion for today, hoping that he would show up. Unfortunately, I can't get a hold of him. He's not appearing today. I don't have the consent judgment as agreed. So I would ask the court to, at this time, enter a default. I did review his answer. His answer is an admission. The only defense he presented is that the items were defective. However, it was the sale of a car, which is as is in Michigan. So based on his answer and his failure to appear, I would ask that a default be entered.
The court will grant the plaintiff's request for entry of a default judgment. My only question is, has the defendant made any payment since that June 7, 2022 hearing?
No, so he was offered either A, to make the payments under the consent judgment, or B, a pretty substantial settlement offer that was going to be due by August or September. He hasn't made an effort towards either.
Ma'am, if you would be so kind to submit a default judgment to the court with the principal damages of $9,580.72. The court sees a filing fee of $75, motion fee of $20, your service fee, your statutory attorney fee. You can email it to the court civil department and they'll send it upstairs for signature. If you wind it back on the no progress docket, the court will now look favorably upon the plaintiff's failure to take any action after the court has ordered into the default judgment. Okay, thank you so much.
Today, Your Honor.
Anything else, ma'am?
No, have a great day.
You too, thank you.
Thank you.
Officer Garcia, I don't have the file yet. Are we?
He just called me and he said that Mackenzie is getting it together and we'll bring it up as soon as possible.
Thank you so much, ma'am. This is 225062 LT. This is Holiday Woods versus Mark Adams. May I have your appearances, please?
Your Honor, for the plaintiff attorney Ian Morton of Pallets Law on behalf of Holiday Woods, P67892.
Thank you, Mr. Morton. Mark Adams or anyone from 72 Mulberry in Belleville. Today is the day and time set for the hearing on plaintiff's request to lift the Sarah stay that's been in place now for about 3 months. Mr. Morton, do you have any update regarding this matter?
No, Your Honor, my client has not received any update whatsoever in regards to the status of the of the payments. I can advise the court as well that the last payment made on the account was on February 7th, but that was only for $100. And other than that, there has been no payments made since November, which at that point, that was $500.
Thank you, sir. Today's hearing being scheduled for 9:30 is now 9:51 by the court's clock. Defendant has failed to appear. The Sarah stay is hereby lifted. And default judgment shall enter in favor of plaintiff and against defendant. Mr. Morton, the rent to retain and court costs, please.
Your Honor, at this time, rents retained are $6,813.50. Court costs of $164. For a total of $6,977.50. This is a possession only action. We'd ask a default judgment be entered.
Thank you. Default judgment shall enter with rent to retain of $6,813.50, $164 in court costs, for a total judgment of $6,977.50. Plaintiff's office will submit that judgment for entry. Anything else in this case, Mr. Morton?
Nothing else, Your Honor.
Thank you, sir. This is 225303 LT. This is Southport Apartments versus Shanisa Hemingway McGlon.
Yes, ma'am.
Your appearances, please.
Yes, ma'am. Shanisa Hemingway McGlone.
Good morning, Your Honor. Joseph for the plaintiff.
Thank you. Today is the day and time set for hearing on plaintiff's request to lift the Sarah stay that's been in place now for 83 days. Mr. Joseph, you've had an opportunity to speak to the defendant in this matter?
Yes, I have, Judge. Judge, there's
Any
no
resolution?
Yeah, there's no resolution. She wants more time. We don't have more time to give. I think she's working with ERAP and some other issues regarding disability. But the plaintiff's position simply is, it's appropriate for a judgment to enter today, and that's our request.
Ms. Hemingway McGlone, what's the status of your application for financial assistance in this matter?
The ERAP program, they said is being processed. That's the 45-day hold that I was in. Last year, Sarah had took care of my balance when I first became disabled. So was waiting for my disability. That's what I'm going through now with my my lupus and my scoliosis. So I was waiting for my long-term disability, but I applied for the ERAP before the deadline. And when I came to court last year, I was put in a 45-day hold. They said it's being processed and they were backed up, but mine is being processed. So I've been checking in with them weekly on that. I know it took a long time last year with the Sarah as well. So they said that's the issue. So I just wanted to know if I could be granted just a little more time, just so I can see if they can, if they are gonna go ahead and process it soon. I know it took a long time with Sarah last year because I don't want to lose my place, but if I've been granted a little more time and it still hasn't went through, then I just have to face whatever.
Unfortunately, ma'am, the court is not in a position to order the plaintiff to wait any longer. The Sarah stay is only supposed to be 30 days. This court allows a little bit more time. And then after plaintiff submitted their request to lift the stay back on January 20th, it still took the court a little while to get today's hearing scheduled. But based on the fact that neither Sarah nor ERAP has paid your apartment complex the money that is due and owing in this matter, the court has no alternative except to lift the Sarah stay that is in place. And the amount of rent that's due and owing in this matter, Mr. Joseph?
Thank you. At this time, Judge, the total amount that is due is $5,790. Court costs are $164. That brings the total judgment request to $5,954 even, with the writ to issue after March 3rd.
Ms. Hemingway, McGlone, do you admit and agree that there's $5,790 due in rent?
Yes, ma'am.
Ma'am, in as much as you admit and acknowledge the amount of rent requested by a plaintiff is accurate, there is not a triable issue of fact, and the plaintiff is entitled to entry of judgment in the amount that they requested. Mr. Joseph, on behalf of Mr. Herman's office, will submit a judgment to the court that shows that amount of rent plus $164 in court costs. The court will sign it and a copy will be mailed to you at the address that we have on file. The suggestion I make to you is that once you receive it, you follow up with those agencies immediately and let them know that judgment is now entered. That might help to expedite your application. Can't guarantee it, but at least you have taken the step to let them know that your situation has become emergent. And if you have not already done so, please apply for state emergency relief. That means you've covered every base that you could possibly get financial assistance from at this time. Anything else, Mr. Joseph?
Nothing further, and I just will re-emphasize to Hemingway McGlone, reach out to management, keep the lines of communication open. Immediately today, reach out to the agencies and see about getting the help. Let them know that a judgment got entered, and see what management might do in light of whatever they tell you at the agencies. Okay.
Okay. Thank you. Am I able to?
Anything else, ma'am?
Am I able to contact you, Mr. Joseph, or no, just go through, just call management, or am I able to contact you personally?
Go through management. That's going to be the best and most direct they're the ones that have the authority and beyond what the court has ordered today, and if they're willing to do so. Okay.
Yes, sir.
Okay. Good luck, ma'am.
Thank you.
Thank you, Judge.
Good to see you, sir. Have a good day.
Likewise.
Mr. Morton, I don't have you scheduled again until 10:30. If there's something else you need to do, unless your defendants appear early, I'll come back out about 10:45.
Sounds good, Your Honor.
Thank you. And Officer Garcia, I'm still waiting for the file, but as soon as that comes upstairs, I'll come right back out and get Mr. Curry's case called to get him on his way.
Thank you, Judge. We're waiting. Thank you.
Thank you.
Hey, Jamie?
You don't have a phone that's down there, do you?
219.
Yes, Judge.
219.
Thank you so much.
Welcome.
Do you want to call?
Does he need to?
I'm sorry, Judge.
Try that one, Jamie.
Does he need to speak to Mr. Nunley?
He denied any type of representation, Judge. Declined.
Okay.
No, he requested.
Can you have Ken call from that number right from your phone? Because 219 is our extension downstairs.
What number are you at?
Judge, he requested MIDC.
232. Judge?
Yes.
You're 261.
261. Thank you.
Thank you.
Sorry.
I think she was saying something about.
Yes, Mackenzie says that Mr. Curry has requested MIDC, so we will get Mr. Nunley back on. We'll get them into a breakout room. I'm still here.
Okay,
As soon as Mr. Nunley's done with Mr. Curry, I'll come right back out.
My apologies, Judge. He's over here stating he does not want an attorney.
Let me get a robe. I'll be right back out.
Thank you, Judge.
Thank you.
What's going to happen, sir, is I'm going to have you stand up.
This is 220334 FY. This is State of Michigan versus Kevin Curry. Sir, state your name for me, please. You're muted. Officer Garcia, you need to fix that for me, please.
Okay. Go ahead, Judge. My apologies. State your name.
State your name for me, sir.
Kevin Curry.
Good morning, Mr. Curry. Sir, the court is in receipt of your file for your felony arraignment this morning. There is a form in the file that you signed that indicates that you want to use the court-appointed attorney this morning.
No, no, I don't.
Oh, sir, but that's what you filled out on this form. Have you had a change of mind?
Yeah, I thought I wrote, I do not.
So, Mr. Curry, despite the form that you have completed, you wish to represent yourself this morning?
Yes, ma'am.
Okay. Mr. Curry, you have an absolute right to be represented by an attorney in this felony matter. Attached to the front of your file is a petition for a court-appointed attorney. The court has signed that. You will be assigned an attorney going forward. They will rely on the phone number that you've supplied to be in communication with you. As indicated previously, sir, today is the day and time set for your arraignment in this matter. It is alleged that on November 9, 2020, in Van Buren Township, you committed count 1, violation of controlled substance. You were in possession of cocaine, heroin, or another narcotic less than 25 grams. It's alleged that you did knowingly or intentionally possess less than 25 grams of a mixture containing the controlled substance fentanyl, contrary to MCL 7403 sub 2 sub A sub 5. That's a felony punishable by up to 4 years in prison and or fines of $25,000 plus court costs. There is also a second or subsequent offense notice on the file. Although the people are not required to notify the court or defendant of prior convictions that may result in an enhanced sentence, the prosecution is voluntarily informing the court that according to their current information, the defendant was previously convicted of violating possession of a controlled substance less than 25 grams, in violation of MCL 333.7403 sub 2 sub A sub 5 on or about August 7th, 1995, and delivery and or possession of with intent to deliver a controlled substance less than 50 grams in violation of MCL 333.7401 sub 2 sub A 4 on or about June 17, 2008, and therefore upon conviction may be subject to an enhanced sentence under MCL 333.7413 sub 1. That's a felony punishable up to prison of 8 years, sir. There's also an habitual offender fourth offense notice. Take notice that the defendant was previously convicted of 3 or more felonies or attempts to commit felonies, and that on or about February 14, 1974, he was convicted of the offense of robbery not armed in violation of MCL 750.530 in the Recorder's Court for the City of Detroit, State of Michigan. And on or about February 9, 1982, he was convicted of the offense of attempted financial transaction device, illegal seller use in violation of MCL 750.92 and MCL 157QA in the Recorder's Court for the City of Detroit, State of Michigan. And on or about December 6, 1994, he was convicted of the offense of larceny under $100 in violation of MCL 750.356A in the Sixth Circuit Court for the County of Oakland, State of Michigan. And on or about August 7, 1995, he was convicted of the offense of controlled substances, possession of cocaine, heroin, or other narcotic less than 25 grams in violation of MCL 333.7403 sub 2 sub A sub 5 in the Recorder's Court for the City of Detroit, State of Michigan. And on or about September 16, 1997, he was convicted of the offense of larceny over $100 in violation of MCL 750.36356A in the Third Circuit Court for the County of Wayne, State of Michigan. On or about October 12, 2000, he was convicted of the offense of attempt, delivery, and or possession with intent to deliver controlled substance less than 50 grams in violation of MCL 750.92 and MCL 333.7401 sub 2 sub A sub 4 in the Third Circuit Court for the County of Wayne, State of Michigan. And on or about June the 17th, 2008, he was convicted of the offense of delivery and or delivery I'm sorry, the offense of delivery and or possession with intent to deliver controlled substance less than 50 grams in violation of MCL 333.7401 sub 2 sub A sub 4 in the Third Circuit Court for the County of Wayne, State of Michigan. And on or about May 18, 2010, he was convicted of the offense of attempted delivery and or possession with intent to deliver a controlled substance less than 50 grams in violation of MCL 750.92 and or MCL 333.7401 sub 2 sub A sub 4 in the Third Circuit Court for the County of Wayne, State of Michigan. And on or about April 12, 2018, he was convicted of the offense of welfare fraud over $500 in violation of MCL 400.601B in the Third Circuit Court for the County of Wayne, State of Michigan. Therefore, defendant is subject to the penalties provided MCL 769.12, that penalty being life if primary offense was penalty of 5 years or more, 15 years or less if primary offense was penalty under 5 years. The maximum penalty cannot be less than the maximum term for a first conviction. Commission of a felony with a motor vehicle advisory. You are charged with the commission of a felony in which a motor vehicle was used. If you are convicted and the judge finds that the conviction is for a felony in which a motor vehicle was used as defined in section 319 of the Michigan Vehicle Code 1949, Public Act 300, MCL 257.319, your driver's license may be suspended by the Secretary of State. Court shall order law enforcement to collect DNA identification profiling sample before sentencing or disposition if not taken at arrest. Mr. Curry, inasmuch as you have waived the representation of a court-appointed attorney this morning, the court will have you stand mute for the charges that you currently face. There is a request for an order for fingerprints, sir. The court is signing that. And will order that your fingerprints be taken. As soon as possible. You have the right to be considered for pretrial release. The recommendation from the Michigan State Police indicates that they're leaving the bond to the court's discretion, indicating that you are in possession of fentanyl. Mr. Curry, do you have any comment as to bond in this matter?
No.
Mr. Curry, based upon your lengthy criminal history that goes back to 1973, along with the age of these charges, court will set your bond in this matter at $5,000, 10%. Your next appearance date will be next Wednesday, March the 1st, 2023 at 8:30 a.m. And that will be with Judge Oakley in courtroom number 2.
Hey, miss,
Sir.
all I have is $200 on me.
Mr. Curry, are you able to contact somebody else to come post a bond for you, sir?
All I have is 200, no, because my people are out of town, ma'am. All I got is 200.
Mr. Curry, respectfully, sir, because again of your lengthy criminal history, the court has set the bond at what the bond is going to be set at. There won't be any adjustment to it today. If you wish to raise the issue with Judge Oakley next Wednesday, you may raise it with him at that time. Anything else, Mr. Curry?
So I gotta have $500 to get out?
Yes, sir. Anything else, sir?
No.
Thank you, Officer Garcia.
Thank you, Your Honor. You can have a seat over there, sir. It's got $500 box. Okay. Yeah.
Thank you. Ms. Jackson?
Maybe all right.
Hi, sir. Can you hear me?
Yes, I can.
Hi, what is your name, please?
Daniel Can.
Daniel, what?
Cann.
And what are you here for this morning?
Pre-sentencing.
Oh, okay. Let me give you, it's a different connection. If you're right, do you have a pen and paper? I have a new number that you need to dial into.
Okay, go ahead.
It's 266-746-8861.
All right, 266-746-8861.
Correct.
Okay, so just join in on that meeting.
Yes.
Okay, sure will.
All right. Bye. Good morning, Mr. Burnt Crant. How are you?
Good morning, Your Honor, or Your Honor. Good morning.
Hey, Mary Ann. Yeah.
Yes, I am in another court in Grand Rapids.
Oh,
My
okay.
case should be called any moment. It's right
Oh.
behind.
Okay. Do you want me, because Miss Jackson is here. Do you want me to wait to put you in a breakout room?
I'm sorry.
That's okay. Do you want me to wait to put you in a breakout room with Miss Jackson?
If you wouldn't mind,
Yep. I'll wait.
We should be
Yep.
called any minute. And I'm sorry, I
That's
keep
okay.
referring to you as Your Honor, but I guess in doubt, that's okay.
You're fine. Yep. Just give me the signal and I'll put you in there.
Thank you so much. Appreciate
You're
it.
welcome.
$5,735. All right, and Ms. Brand, move on.
I'm sorry, Mackenzie, I still had the file in 220334 FY, State of Michigan versus Kevin Curry. The court has received information that law enforcement seeks personal bond in this matter. The record will now reflect Mr. Curry's bond at 5,000 personal, which puts his return date still on March the 1st, but the time will be 9 a.m. with Judge Oakley, March 1st, 9 a.m. with Judge Oakley for PCC. File will be downstairs momentarily.
Mr. Bergkrant, are you still with the other court?
I am.
Okay, all right. I didn't know if I missed you saying something to you or not.
No, it's,
Okay.
thank you
All
for
right,
being.
thank you.
Okay, I have you both on Zooms. Okay, thank you.
Hey, welcome back, Royce.
Hello, can you hear me?
Yep, I can hear you now. Welcome back.
Thank you. Sorry for the delay. Stuck.
Who are you here for?
The arraignment for Kevin Curry.
He didn't want MIDC.
Oh, he didn't?
No.
Okay. Well, there you go. Then
Okay.
I knocked that one out of the park then, apparently.
Good job, man. Good seeing you again.
See ya.
Okay, bye.
This is 2-2-6051 LT Rawsonville Woods versus Leilani Cimitera and Richard Placencia. Sorry.
Your Honor, Attorney Ian Morton of Pallets Law on behalf of Rawsonville P67892. I believe it's, I know the first last name is Sumatra.
Sumatra.
Yeah.
Thank you. Or anyone from 9 Carriage Lane, Belleville, Michigan. Mr. Morton, today is the day and time set for hearing on plaintiff's request to lift the Sarah ERAP stay that's been in place for 48 days. The documentation that came back from plaintiff's office indicates that the defendants have been denied the assistance of the ERAP program. This case was scheduled for 9:30. For 10:30. It's now 10:46 by this court's clock, and the defendants have failed to appear. There are no unidentified persons in the court's breakout sessions. There's no one in the court's virtual waiting room. There's no one on site claiming to be here for this case. The court will lift the stay that has been in place, and based on the defendant's failure to appear, Mr. Morton, how would you like to proceed?
Your Honor, at this time, we would ask a default judgment for possession to be entered, and that is correct, that as we marked it in the folder, my client did speak to a representative ERAP and confirmed that was it the ERAP, they were denied for ERAP, and it had to do with the previous denial related to some SERA assistance that they had previously received. we would seek a default judgment for possession. The last payment that was made on the account, Your Honor, was back in August of 2022. As of today's date, rents retained are $12,310.53, court costs of $188, for a total of $12,498.53.
Mr. Morton, if your office was submitted a default judgment that shows a past due rent of $12,310.53, $188 in court costs, the total judgment of $12,498.53, the court will sign that. Anything else in this matter, sir?
Nothing else in this matter, Your Honor. Thank you very much.
Thank you, Mr. Morton. Have a good afternoon.
You too.
Mr. Bernkran, have you had the opportunity to speak to Ms. Jackson yet?
No, I have not, Your Honor, but I would welcome the opportunity, and I apologize for the being.
Don't apologize for being busy, sir. We'll get you into a breakout room. Ms. Jackson, please go into the breakout room with the attorney to discuss this matter. This is 22543-6LT. This is MIMG Gateway Townhomes versus Jamisa Jackson. May I have your appearances, please?
Yes, Jamisa Jackson.
John Bernkran for Gateway Townhomes, the plaintiff landlord.
Thank you. Today is the day and time set for hearing on plans requested with the Sarah Stay ERAP stay actually that's been in place for 83 days. The parties have had an opportunity to speak. Mr. Burnkrant, is there any resolution in this matter?
Yes, Your Honor, I'm happy to report that I've talked to Ms. Jackson, and she understands the terms of a consent judgment, and she's in agreement with a consent judgment, and she's also in agreement to me signing her name to a consent judgment. The judgment would indicate possession only. The amount to redeem would be $5,113 plus $167 in court costs, for a total redemption figure of $5,280, which must be paid in full on or before March 3rd, 2023, with certified funds, or she'd have to surrender possession and turn in her keys to management by March 3rd, 2023. I've also indicated and will indicate in the judgment that she has 10 days to appeal the entry of this particular judgment, as well as 3 days to come back to court and ask Your Honor to set aside the judgment, but she has to have valid terms, which Your Honor would honor, and then we would have a trial.
Mr. Burnkrant, I'm not sure, maybe I misunderstood you. Ms. Jackson, turn your camera on for me, please. Sir,
Yes,
did you
ma'am.
say pay $5,280 by March 3rd or surrender keys by March 30th?
No,
Or did I
March.
misunderstand?
If I misstated, I apologize. The surrendering of the keys would have to be March 3rd, 2023, or payment in full by March 3rd, 2023.
Thank you. Ms. Jackson, I just wanted to see your face while I asked you, were you able to hear the attorney just now?
Yes,
And that's your agreement that you will pay $5,280 by March 3rd or vacate the property?
yes,
And that because your apartment complex is represented by an attorney and you are not, that the judgment is not final and enforceable for 3 days?
okay,
And you authorize, because you appear on Zoom, there is not a signed consent judgment. You authorize the attorney to sign your name to the consent judgment?
yes, I did.
The court has written the terms into the file. Mr. Burnkrant's office will submit a judgment that has those same terms to the court. Once it comes upstairs, I'll sign it and a copy will be mailed to you at the address that we have on file. Anything else, Mr. Burnkrant?
Nothing further, Your Honor. Thank you.
Anything else, Ms. Jackson?
No, that's it. Thank you.
Thank you, ma'am. Good luck to you. Have a good afternoon.
Thank you. You too.
Thank you.
Bye-bye.
And Mary Ann, I will show us as being adjourned. That was our last scheduled case of the day, and I haven't heard anything else from downstairs.